All right, we're back on the record, and up next we have a motion in People v. Kenneth Godley, file 24-6911FH. Counsel, you want to state your appearances, please?
Anthony Juliet on behalf of People.
No Aguilar for Mr. Godley, who is not present today, who requests to speak the attorney's on.
Okay, this matter is scheduled for a jury trial on Monday morning. I did meet with counsel in chambers yesterday afternoon, and the prosecutor indicated they wanted to amend the information, and indicated I would hear the motion this morning. So I have received the people's written motion to amend the information. Mr. Juliet, go ahead.
Yes, Your Honor, I'm seeking to amend the information that was filed in this matter. The original count was larceny by conversion, $1,000 to $20,000. I'm seeking to amend that count to stealing, retaining a financial transaction device without consent. As the court knows, the court rule allows the court can permit the prosecutor to file an amended information before, during, or even after trial. And with trial being Monday, I wanted to get this heard sooner rather than later. I cited a few cases in the motion that suggests that the defendant in this case would not be unfairly surprised or prejudiced due to the amendment. I mean, I understand that it's a new charge, which is case law still allows, but the court rule requires that the defendant be substantially prejudiced, or the surprise be substantially surprise the defendant or prejudice him. And I don't think we have that in this case. Albeit different charges, the proofs are going to be the same, the witnesses are going to be the same. And frankly, within the original larceny by conversion charge, I would have necessarily had to prove the elements of the stealing or retaining the FTD without consent. So I don't know if that really substantially changes any sort of defense. It certainly doesn't change any my trial strategy and what I intend to prove. So I'd leave it at that and ask the court to grant the motion.
Can you help me out a little bit? There hasn't been any motions in this file, and the prelim, it looks like, was not conducted. So I'm at a little bit of a disadvantage in that I honestly don't quite understand or know what the case is about. Can you give me the 30-second version about what the facts as you allege them are that would support this criminal charge?
Sure. So back in 2022, the alleged victim in this case entered into what I would consider a verbal contractual agreement for an engine to be installed on his boat. He bought a new engine on Facebook Marketplace and entered into an oral contract with the defendant to replace that boat.
So the victim purchased the engine?
Correct.
Okay. And the defendant was hired to install it?
Correct. And around that time, during April 2022, the defendant picked up the boat from the alleged victim's residence. He required a $2,000 down payment. The alleged victim in this case gave the $2,000 down payment in the form of credit card information, which the defendant then took and what I would consider paid a personal debt off at an auto mechanic shop in Indian River. That's largely the basis for the proposed amendment. The original larceny involved allegations of converting the engine to his own use, the old engine to his own use, and the boat to his own use. But frankly, my strategy in this trial was largely on the $2,000 down payment, because I'm not sure that the other stuff was actually subject to a conversion.
So the $2,000 down payment that the complainant made to the defendant did not give him a card that they ran through somewhere, just gave them the numbers? Is that right? Gave them the information?
Correct.
And then did the defendant put that into one of his own accounts and then use those funds improperly? Is that the allegation? Or are you saying that he used that credit card information at a different point of payment to directly pay a different debt with the information?
That is largely my argument, and this goes to the, I guess, the scope of the consent given to use that card. And this may be a legal argument, I guess, but it's my position that when he gave him the credit card information as the down payment, he was expecting a down payment with the work to start on his boat. The defendant then goes to use that card information to pay a personal debt, which was outside the scope of the consent used, or the consent given to use the financial transaction device.
Okay, I just want to understand that the mechanics of the payment, that without the physical card, but with the account information from the card, the defendant used that information to provide to yet somebody else to satisfy a debt?
Correct.
All right, Mr. Nightingale, your response?
Thank you, Judge. So I think first I'll just respond to the motion to amend. After speaking with both Mr. Juliet yesterday in the court in chambers, I was able to have a conversation with Mr. Godley. I think what we would prefer to do at this point, because as the court's already noted, the record from the prelim is non-existent, that we would prefer if the people would be amenable to waive this back and conduct a preliminary examination on the new charge. I understand that a lot of these elements are the same, that the factual situation here has not changed. And in that sense, most of the evidence presented at trial would be similar in nature to the original charge. I'm not here to dispute that. I think what my big hang up is, as far as does this or does this not change my defense? I guess I would just say that I think it has to change the defense, because Mr. Juliet is a smart guy. And, we had a long conversation about this yesterday, in which Mr. Juliet's very convinced that the defense works and is valid for the original charge, but is not convinced that it works for this charge. And so my defense does have to change if that is his position. And so I would just say, I guess that if the court's willing to waive this back, we would not object to this, but I have to object to it if we're still planning on going forward to jury on Monday, because it doesn't change my defense. I do believe it is an unfair surprise at this point, less than 48 hours away from jury trial date, to totally change the charging information.
Okay, well, and the backdrop for this then is that on as recently as May 7th of this year, the Michigan Supreme Court entered an order in People v. Clinton, docket 166210, that seems to call into question the criminal liability for a larceny by conversion under these circumstances. And Mr. Juliet, as I understand that is part of the motivation to change to amend the information, in addition to, as you said, that your theory really hinged on the use of the financial transaction device anyway.
Correct.
Correct.
As part of the conversion charge and the Clinton case that substantially changed my outlook on this.
So this is a bit tricky procedurally, because then what I don't have in front of me is a motion to quash or dismiss. Partly there's no record for that, and so I don't know that I can formulate a clear opinion about that or take any action on that. But as I review the Clinton opinion and looking at the financial transaction device statute, as I sit here, I'm not certain whether this charge solves your People v. Clinton problem or not. So if we go forward with the trial on Monday, then we're going to have a legal argument on a directed motion for directed verdict of acquittal. And after I hear the proofs, I don't know whether I grant it or not. It seems to me that that might well be a waste of jury's time if it really comes down to an application of law to facts. So rather than develop a factual record with a jury present, I guess my preference would be to develop that factual record by virtue of a preliminary examination. But I don't know that I can do that on my own.
Judge.
Well, I guess I mean, the case law is a little bit murky about whether when the court grants a motion to amend an information, a remand for a prelim is required. As I understand the case law, a remand for a new prelim is not always required. In fact, an amendment can happen even during a trial, as Mr. Juliet pointed out, but that there are some situations where a remand for a preliminary examination on the new charge is appropriate. I think this would be one of those. So, Mr. Juliet, I would grant your motion to amend the information. However, I would, on the amended information, grant what I heard to be the defendant's request for preliminary examination on that information. So I'm accepting the amended information as filed, but remanding it for a preliminary examination on that, or do I remand it without accepting the information? That's probably better.
Yeah,
Procedurally, yeah.
I think so.
Okay. All right. So the motion to amend would be granted, but I think that a preliminary examination to flesh out these issues is warranted because it may well be that I don't know what the district court would think about that, whether there's sufficient proof to go forward. And if there is, the defense may want to file a motion to quash, and we may have to hash this out with some of the case law and see. I'd rather that if we're going in front of a jury, I'm confident that if the facts are proven beyond a reasonable doubt, that it does indeed constitute a violation of the law. So I'll enter an order remanding it to the district court for a preliminary examination.
Thank you.
That'll take the trial off for Monday.
Thank you. I will let Mr. Gauthier answer this as well.
Okay. All right. Thank you. We'll be adjourned.